Hola, buenos días. En primer lugar, dar las gracias.
Good morning. First of all, I would like to take this opportunity to thank the Foundation and Pilar for kindly inviting me to participate in your Congress. I became aware of MCS and started attending your sessions in the third or fourth Congress at Brunete. And I began to learn more about what's happening today, and I'm sure that in the future we're going to have more and more problems and more MCS cases. I work with a group of lawyers, and we provide counseling to our clients. I'm a specialist in social security issues. After 2000, the year 2000, we began to see patients with diseases that nobody knew of. And little by little, we started to learn more about this condition. We attended meetings, we attended congresses, and right now I believe that we have about 150 MCS cases. Some have also fibromyalgia, other environmental diseases, and chronic fatigue syndrome. I will be describing our experience and draw some conclusions. I will be describing what we have observed and what we have experienced during this period of time, and will try to draw some conclusions. We believe that most of us, at least from a professional standpoint, will be dedicating much of our time and much of our endeavor in this field. Here we have representation of what occurred at that time. This was a situation at that time. This represents MCS, and also we have here the rest of the social representatives, health authorities, judges, forensic doctors, legal doctors, those representing legal medicine. So you have a ship, iceberg, with symptoms on top. The lawyer usually says that this patient presents all these symptoms. And what we should take into account also that we need the involvement of the other parts of the components of this iceberg. We only look at the top, and it is today really much easier to recognize that an individual has disease, but it is a common disease, instead of getting down to the root of the question. This is taken from a publication of Jordi Biols in the 90s, the description of MCS, its definition, an acquired syndrome related to exposure, insult, or disease that can be documented arising from the environment. That was the definition at that time. Perhaps several years from now, we may see that this is not only acquired, that this is also related with genes, but that might occur in the future. But there are many products that exist today that produce these symptoms and which is acquired from the exposure to these substances. I think this also should be updated. This study states that 80% of patients with MCS know when, where, and what substance caused their condition. 20% do not. From my experience, there's a higher incidence of patients that know when, where, and what caused their disease, their MCS. Here's a study conducted by Dr. Nogueira and Dr. Fernandez Solá on 165 cases of patients with MCS. It is a study, we'll see later on, that distinguishes between occupational and non-occupational disease of these 165 patients. There is a high prevalence in women, as we have heard, a higher incidence basically in those who are working at the office, health professionals, those working the hospital staff, and those doing cleaning work at hospitals. So those are basically the three occupations where there's a higher prevalence of MCS. Surprisingly, there's a higher incidence of MCS in workers, employees, those working for administration. And really, it would be necessary to try to identify the reasons why there's a higher incidence in administration, employees, and buildings. There's a higher exposure rate. And I'm sure we will find out that it is not always the product that's responsible for this complication. I'm referring to ventilation systems. If you have workers in a closed area exposed to a substance, very often that's the cause of the disease, but however, if there's improper ventilation, exposure alone to a substance may not be the only cause of the disease, but also because of poor use of the different systems available in these government buildings. It is necessary to know the cause in order to be able to identify the disease. It will help to identify the disease, to know more about the disease, and to prevent the disease. Many of the patients come or consult for chronic fatigue. Our questions lead us to get further information on the patient's condition. And our experience show that following the interview with the patients, the lawyers refer the patients to the appropriate health professional, to the appropriate doctor. And I think that the first thing doctors at the outpatient clinic should do is to ask patients more specific questions and to learn about their workplace, to learn about their situation or conditions at home, their housing conditions. We had a case of a man who had a psychotic attack and even attempted suicide. He had used the evaporate and with benzene and had this exposure to hydrocarbons. He was sent to the doctors, and now he is disabled and totally disabled, total incapacity because of exposure to these hydrocarbons. And he has MCS and neurocognitive disorders and also CFS, chronic fatigue. So it's necessary to understand the disease in order to prevent the disease. But according to our law, it's a company that must take the necessary measures to avoid this. It is the companies. in 10% of the cases are known. We have limits that have been established, limits for the amount of TLVs, these values. Now, they say that, well, I am complying with law, complying with the law because I meet all the established maximum values. So I think also changes should be done in that regard in order to prevent the disease and to prevent the exacerbation of disease, particularly in those that already have sensitivity to this disease and to these substances. Now, when someone has when someone is off work, this may be due to occupational causes, occupational diseases, or just a common disease. And patients and lawyers have to work together in order to achieve these changes and get this disease to be recognized. Otherwise, we will not be able to take preventive measures against this disease.
Es el SQM de hace 50 años.
Asbestos, for instance, the case of asbestos, we were told before that the maximum limits have been established, and if these limits aren't, if you have values less than these limits, you will not get that disease. But now those that have been exposed to asbestos are developing cancer. So if we do not demand that our rights be met, that will not be recognized as an occupational disease. Someone that has been exposed because of occupation, that person's occupation to asbestos and develops lung cancer, that will not be considered as an occupational disease. So it's necessary for us to work to get that to be recognized, that it is a cause and it is an occupational disease. This is the Social Security Act, Article 115. This dates back to 1994. If there's an accident, for instance, one falls from a scaffolding, that is clearly described in this article. But also, this was written this dates back to 1956 originally and has been modified subsequently. Here you have the concept of occupational accident. Accident occurring when the worker is executing his or her tasks. In other instances, for instance, the difficulty arises because it's not embodied in this law of exposure to a substance one is sensitive to. And also, a person may have a previous susceptibility to certain exposure to substances in the workplace, and that also would be considered as an occupational accident. So in the end, if we have many court decisions that consider that a cleaning product that's present in the workplace is the cause of that disease, then they will be forced to take measures. You also have here the so-called intercurrent diseases. Intercurrent diseases, if it is also associated with exposure to substance, would also be considered as an occupational disease. One that develops MCS and after 10 years develops Parkinson's disease. Parkinson's disease arising from MCS should also be considered as an occupational accident. although it's an intercurrent disease that has developed to Parkinson's disease. That's very difficult to demonstrate, but now we begin to have cases that show evidence of this. As Plato said, it's very difficult to distinguish between the cause of something, if that something is really the cause. Here we have the different criteria that helps us determine whether MCS is due to exposure at work, such as a patient has not had previous manifestations of this condition prior to work, and no fibromyalgia or other comorbidity, and if there has been exposure to chemical substances that are documented. I'll skip through this. What it simply states is that the concept of occupational accident changed and included little by little these different concepts, not only directly related with the execution of a task, but also with some of the aspects that I mentioned before. However, professional or occupational disease follows a scale. You have a list of the Social Security system, a list of occupational diseases. These are the diseases that are recognized. A product, an activity, and an occupation are related. And the other party must demonstrate that it is not true. So this scale, this list, have two parts: physical agents and chemical agents. We have asbestos, for instance, pleural mesothelioma or lung cancer in a person working in the cement industry. That's considered as an occupational accident. Now, concerning the product, here the product, the activity are mentioned. And you have a list of diseases. Now, concerning the chemical agents, it only states, it only lists the products and activities, but not diseases. Any systemic disease that can be related to the chemical products. It just states any systemic disease that can be related to this product. That is not, but they are not listed. In 68, we already had a description of environmental diseases because all of these products can cause disease. Now, if you look at the court decisions, there is not a single court decision where someone has identified a product that has caused a specific disease. No case of kidney cancer, renal cancer, for instance, has been related to a specific product. Now, systemic disease, can there be anything more systemic as MCS? I think that's clear. Now, if you can demonstrate that in your workplace you're exposed to that chemical substance, then, and of course, if you demonstrate that you have MCS, it's the other party that will have the onus or the burden of proof. Here I've taken just a few of these organochlorinated, organophosphorated substances, just a few examples. For hygienic use, cleaning products, etc. for cleaning use in buildings, well, that occurs every day. How many buildings, how many companies are exposed to these products? Everyone that has been, even the cleaning people at the hotels where they're cleaning, some are fumigating the building, and they're exposed to these substances. Now, if you prove that you have MCS or CFS, then that should be considered to be an occupational disease. You have, that is present all. You have practically a list of all of the chemical products there, classified by groups such as phenols, alcohols, etc. You have all of these products. They fall into all of the categories included in this list of the Social Security. And I'm sure that you will find the products that are not even used listed there. This was a court sentence, a court in Madrid. It is the first time that MCS has been recognized as an occupational disease, and the CFS. And this has been caused by exposure to chemical products at work and has led to this condition. So this is clearly recognized and defined, described in this sentence. And this type of sentences are going to be useful for lawyers, for their clients, and also for doctors. It's easier to read a court sentence than to read medical literature. And you can see here that also states specifically that medically and toxicologically, the diseases that the patient present are clearly related to long-term exposure to these chemical products. And here, this court sentence also shows that the subject had been exposed to the product directly, and also his colleagues. The products being used by his colleagues had indirectly caused, he had been indirectly exposed to the other products used by the colleagues, by the co-workers. So I think really this is a very interesting court sentence. We have to wait until that sentence has been confirmed by the higher courts of Madrid. As I said, there are many products in the list of the Social Security. You have here, you have clear identification of products, and they are classified by groups. There is another concept also that is undergoing innovation, the so-called non-occupational accidents. In our country, we prefer to do the easy things and put people in the same, under the same category, occupational accident. This is what we would like to call as environmental accident, not non-occupational accident. Accident, if it is an acquired disease and there's a cause, that cause might be considered to be an accident because that was not done voluntarily. One does not want to be ill voluntarily. So that can be considered as an accident in that broad sense. if you dig a well and all of the residues, all of the waste get into that well, and because of some pumping systems, you are exposed. Because of your house equipment and facility has been connected to some part of those pipelines. Well, then that's also an accident. There was a case where one had been exposed to gases and fumes that produced MCS and chronic fatigue syndrome, and that was not an occupational disease. That's not a common disease. That is not a slow and gradually developing disease leading to disability and total incapacity. This was an exposure to these environmental fumes. Also, exposure to silicone in a breast implant, for instance, is not a non-occupational accident. And it's interesting for this to be recognized, its due cause to be recognized. Any operation that involves exposure to a substance that might lead to disability should be considered to fall into this group. First, it has to be recognized as an accident, whether it is occupational or non-occupational, and then we'll describe the cause. And through these court sentences, we will be able to claim indemnity rights and compensation. We claim damages and compensation for the injuries caused. But if disability is considered a common disease, then we cannot claim for damages. The right to health, any food, any element in the environment, any exposure to chemical product can be considered as a non-occupational accident. It is an accident because one does not expose oneself to something harmful willingly and voluntarily. You have the norms on the workplace hygiene and safety, on products, and also I was surprised to find that the cereals of children, of babies, may contain up to 0. I don't know how much milligrams of organophosphates products. I was really surprised to see that. But there is not one single norm or regulation that brings all of these different aspects together, not separated according to products or according to groups of products. I think there has to be a law that embodies all of this. This is a mixed bag. That's what we do. That's easy to do. We get quick results, and that's easily done. I had a case that had MCS and CFS, and had consulted the lawyer, and the lawyer said, well, try to get your total disability to be recognized. It's easier to do that. Now, that's what his lawyer said. And he came to me, and I told him that this problem will never be solved unless we get down to the root cause. So it's easy to put things in a mixed bag. it's easier for lawyers also to consider these cases as a common disease, but we'll never solve anything if that is our approach. So I convinced my client to file for a claim for damages and compensation. We have the International Code for Diseases, where all of the different diseases in Spain or worldwide are listed. This is an international code, but MCS is not included. We have CFS, fibromyalgia, but MCS is not. And through a state committee of representing associations, we approached the Ministry of Health and we demanded that MCS be included. We have a committee of experts, all physicians, all doctors, and we wanted them to prepare a protocol for MCS. And we're also lobbying at the level of the WHO in Geneva. And we were received, and we were told that in May, starting May this year, they're reviewing this international code, and that will not be completed until 2015, I believe. But you see, if this is included in the ICD, if a doctor wants to authorize, if the general practitioner wants to authorize that the total incapacity of the or sickness benefit of a person, he can easily turn to the ICD and quote that. So I think it's necessary to get MCS included in the International Code of Diseases. Also, it is necessary to work hard before the Assembly of 2015 so that we can lobby for inclusion of MCS into the ICD. So we want also to work at the level of the U.S. and lobby in the U.S. to collaborate there, and also to lobby at the same time here in Spain, so that we will be able to force our health authorities to lobby at the level of the WHO at the Assembly meeting in 2015. As I said, fibromyalgia, CFS are included, but MCS is not. We want MCS to be included in that code, and we are starting already in Catalonia to get the authorities to attend and to recognize this condition in this patient. So working hard for that now. We're doing a follow-up, and we want them also to follow up on these cases. Thank you very much for your attention.